Greetings, my fellow Americans, and welcome to another episode of the Great Montana Conspiracy Podcast. Tonight we're going to be talking about public defenders, and public defenders more appropriately in the rights to counsel and how twisted and broken our system that was put into place over 50 years ago by the United States Supreme Court has just become confabulated, and of course Montana only makes it worse. The reason why this subject comes up is this week there was a notable news article that was brought to my attention. Missoula District Court Judge Donald L. Harris of the 13th Judicial District Court of Montana in and for Yellowstone County. He held the state's head public defender was in contempt of a court order he had made, compelling the Office of Public Defender to immediately represent 17 defendants who he had identified had not been yet provided counsel. Now, the case, for reference, is known as In Re, the Office of State Public Defender, cause number SB 2021-1. And again, that's in the 13th Judicial District Court of Montana, Yellowstone County. As I mentioned, the primary reason for bringing this was the judge identified there were 17 defendants who were without counsel and ordered the Office of Public Defender to immediately appoint counsel to them within 3 business days. The Office of Public Defender argued, correctly by the way, that it was grossly under-budgeted and understaffed. The state legislature is responsible for providing the budget for the Office of Public Defender. The state legislature routinely underfunds this department, making it impossible for them to this office to attract attorneys, because to delegate out the money that's given to the individual offices is so minuscule that they have to offer ridiculously low amounts to attorneys who can get a lot more in private practice. And therefore, when they leave law school, they're not leaving with the intention of going and working for a $10 an hour job when they can get a $50 an hour job in private practice. Obviously, that's not at all reflective of what the actual salaries are. But the idea being that attorneys who can go into private practice, work for individual firms, are going to earn substantially more money than working for a government agency in general. But the Office of Public Defender of Montana is so grossly underfunded, they simply cannot afford to offer more money to attract better counsel. And the number of attorneys that are actually allotted for do not meet the burden that's created by the state running a prison for profit system that mass funnels in people by the thousands. So the Office of Public Defender correctly argued that they are understaffed and underfunded. There's just no way to assign counsel if counsel does not exist. If there are existing vacancies in an office because they cannot attract attorneys to fill those vacancies, or if the burden upon them is so great that the attorneys they do have cannot handle more cases. The state legislature will not budget the funds, and that's where the fault lies. The order is essentially punishing the Office of Disciplinary, or the Office of Public Defender, for legislatures refusing to provide adequate funding. So what you have here is a situation where Judge Harris is essentially saying that statutory obligation to perform outweighs an ability to do so. And I want to read a critical part of this order, which really sums up where Harris's mind is at. He writes that while the court understands the OPD's explanation, it is no defense to the constitutional and statutory requirements that public defenders be immediately assigned to defendants when ordered to do so by a court. Montana Constitution guarantees that, quote, right and justice shall be admitted without sale, denial, or delay. Montana Constitution, Article 2, Paragraph 16. Montana's Constitution guarantees the defendant the right to counsel and to a speedy trial. Montana Constitution, Article 2, Paragraph 24. To preserve these fundamental rights, Montana Code annotated Section 47-1-104-3, parentheses 3 by the way, requires the immediate assignment of public defenders in criminal cases when the assignment is ordered by a court. These conditional guarantees and statutory mandates are not contingent upon the OPT's success in securing an adequate budget or upon the OPT's decision on how to allocate its existing funds. Okay. Do you get that? The constitutional guarantee upon the state. The Constitution does not say that the Office of Public Defender is responsible entirely for doing this. It says the state. The burdens are upon the state. That means all offices of the state, not just upon one agency. Yes, the law says the OPD must require, but the state must make it possible for the OPD to do its job. The Office of Public Defender must be able to perform this function before it can do it. Not only does it require that counsel be provided, it provides that adequate counsel be provided. If there's not enough staff, if a staff person on a regular basis can handle maybe 20 cases, again, not an accurate reflection, just throwing a number out there, and you give them 50, can they honestly be said to be giving adequate counsel to any of their clients? If they can handle a burden of 20 and do it adequately, if you give them 50, it's inadequate. What this judge is saying is that I don't care if you provide inadequate counsel. I don't care if you completely are ineffective and inadequate in any capacity. All I care about is you do the statutory minimum of giving them a counsel to represent them in court, so they are not without counsel, so we don't have to worry about the possibility of their prosecutions being overturned for lack of counsel. I'll provide a link to this ridiculous order in the summary of this case, which reminds me, I should take a point here to remind you that if you're watching this on YouTube, please like and subscribe. Normally I start this at the beginning of the video, and I forgot. But please like and subscribe. If you do not see the text attached to this video, if you're watching on a platform that does not have it, you can always visit us on monspiracy.podbean.com, which is where this podcast originates, so the text will definitely be there. But regardless of the platform you're watching it on, please take the time to like and subscribe and share the information with your friends. And as I mentioned, I will provide a link to this order of Judge Harris's in the description of this particular podcast so you guys can see it and understand exactly how perverse this is. Though the court is right of the government's obligation, the government does have an obligation to provide fair and adequate counsel to indigent clients, indigent defendants, people who are accused of a crime but can't afford the defense. But it applies the full burden on the Office of Public Defender, not the government as a whole. The head public defender has now been ordered to pay $8,500 as penalty for doing what she has no power to do. Like ordering a nurse to learn brain surgery in 3 days, but not punishing the doctor who can do it already. Or worse, punishing someone for sitting in jail and not appearing in a court hearing, but not punishing the jailers who will not bring that person from the cell to the court. Well, you were ordered to be here, Mr. Jones. Why weren't you here? Well, the jail wouldn't bring you. That's no excuse. It's not a justification. You were ordered to be here. You're not here. You're going to get sentenced and penalized and be held in contempt for not appearing. How does that make sense? If someone is incapable of doing something, and there's definitely a recognition that a problem exists. But the judge is saying, I don't care if you don't have the money. I don't care if you don't have the staff. I don't care. You are obligated to do this, even if you have no money, even if you have no staff, even if you have no way to give them their constitutional minimum requirement of fair and competent counsel. I don't care. I want an attorney to assign to this. I don't care if it makes the client not have a fair appointment of counsel or somebody who can actually look at their case and find them. I don't want that. In fact, the judge is literally saying he doesn't care if the individual OPD counsel that's assigned to individual defendants are adequate to the task. He's saying he doesn't care if there's not enough money to attract decent attorneys or attract enough attorneys. He doesn't care. All he cares about is whether or not there's an attorney assigned to the case just so he can meet the bare constitutional minimum that they be appointed counsel. Why isn't he issuing an order against the legislature? Why isn't he issuing an order? Why is he even trying to do this at all? Because prison for profit. The more people that are going to run through, the more money the county makes from the state gets from the federal government, the more the counties get from the state system. It all funnels down. And the less effective the attorneys are to represent these indigent defendants, the more likely they are to be prosecuted, convicted, and to feed into the prison for profit system. That's where this mandate is. If it cannot be done, if it's impossible to do what the court orders it to do, or to do what the law requires, how can it possibly be done with any kind of effectiveness? It's not the Office of Public Defender's fault that the legislature will not give them the money to do their job. It's not. If you pass a law that says someone has to grow wings, does it suddenly make it possible for anyone to just sprout wings because the law says to? Of course not. There must be some kind of mechanism to allow for those wings to be either implanted or grown or something else to comply with the law, because if there's not a measure for that, then you're punishing for someone for something they are incapable of doing. I am a male. I cannot give birth to a child. It is a physical, biological impossibility. But if they pass a law that says every citizen in the state of Montana must bear a child by X years of life, let's say 40, every adult must become pregnant and birth a child, 50% of the state is going to go to prison because it's physically impossible to do unless you suddenly have some way to implant an artificial womb inside every man. Again, the state made the law, the state has an obligation to do this. But it's a completely irrational argument that the Office of Public Defender should be penalized for not having the money when the state itself is the bearer of this burden, not the Office of Public Defender. The thing is, this story brings up the subject of Montana's history with providing legal counsel for indigent criminals, or for individual criminal defendants. But before we can talk about Montana, we need to look back at the national scene and what led to this. Because Montana got sued over this back in 2002. They got sued, okay? They got sued for just this reason. And we're right back to square one. But we have to talk about what brought us to this point. First of all, let me explain the applicable standard here. The Sixth Amendment to the United States Constitution reads, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." That's the actual literal language of the Sixth Amendment of the United States Constitution. So what happens when you can't afford it? What happens when you have no money? You're accused of a crime, but you have no money to pay for an attorney. Where does your right go? Well, the United States Supreme Court entered their opinion on this. In 1961, there was a burglary, June 3rd, 1961. And it sparked the lawsuit, or a case of Gideon versus Wainwright, which was 372 U.S. 335. And again, this is volume 372, U.S. Reporter, page 335. Clarence Earl Gideon was the accused of this case. A witness claimed to have seen him at the site of the burglary, leaving with wine, Coca-Cola, and change in his pocket. Based on this sole witness statement, without finding any stolen property in Mr. Gideon's possession, without verifying, seeking an alibi, anything like that, they arrested Mr. Gideon, and he ended up being convicted to a 5-year prison sentence for burglary with intent to commit petty larceny. The first thing he did was he filed a habeas corpus with the state of Florida and said, I was denied counsel. He actually asked for counsel at the hearing in front of the judge and said, Your Honor, I can't afford counsel. The Constitution, the Sixth Amendment, says I'm entitled to it. And the judge says, we only give counsel, this is the state of Florida, by the way, we only give counsel to capital crimes. Therefore, it's not a capital crime, you're not entitled to counsel. He filed a habeas corpus with the Florida State Supreme Court. They denied it. He then filed from his prison cell, a handwritten with pencil. Mr. Gideon wrote a petition for writ of certiorari and filed it with the U.S. Supreme Court. The Supreme Court, ironically enough, assigned Gideon counsel. Assigned him one Abe Fortas, who, by the way, was a future Supreme Court justice. At the time he was not, but he would go on in his later career to becoming a U.S. Supreme Court justice. And he made two primary arguments. The first was that a layman could not be expected to understand the law enough to defend against a criminal conviction. Had no idea how to present whether hearsay was involved, whether evidence was admissible, inadmissible. It was simply an unconscionable act to sit here and ask a defendant who had no background in law to understand law and defend himself against attorneys from the state who obviously were well versed in it. The second argument, which is probably the most interesting argument that was made, was that even the best attorneys in the country retained counsel when they were accused of crimes. If attorneys who knew the law needed attorneys to represent them in criminal defenses, how could a layman contend? The U.S. Supreme Court agreed unanimously. Very rare, but unanimously agreed. And this is a bygone era where the U.S. Supreme Court was actually stood for principles, not politics. You didn't have one side governed by liberals and one side governed by conservatives. You had a court that worked upon law. What was the law? What was a fair assessment of law? And Gideon is a perfect example where the U.S. Supreme Court, not divided by politics, not conservative versus liberal sides of the court, based on law, decided unanimously that this case was clearly not what it should be. And I want to read Gideon's summary here. Lawyers in criminal courts are necessities, not luxuries. The right of one charged with crime to counsel may not be deemed fundamental and essentials to fair trials in some countries, but not in ours. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. A defendant's need for a lawyer is nowhere better stated than the moving words of Mr. Justice Sutherland in Powell v. Alabama. And this following quote comes from Powell v. Alabama. The right to be heard would be, in many cases, of little avail if I did not comprehend the right to be heard by counsel. If it did not comprehend the right to be heard by counsel. Even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with crime, he is incapable, generally, of determining for himself whether the indictment is good or bad. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial without a proper charge and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he have a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he be not guilty, he faces the danger of conviction because he does not know how to establish his innocence. End quote. By the way, for the record, Powell v. Alabama was dealing with a capital case. And therefore, the reason why the Florida court originally told Mr. Gideon that he was only entitled to counsel in capital cases was because the U.S. Supreme Court case which summarized that issue, Powell versus Alabama, only was discussing a capital case, whether an individual accused of a capital crime of murder was entitled to counsel to save his life. Because the United States Supreme Court was only dealing with that subject, it was interpreted by the lower courts thereafter that this right only applied if it was a capital case. Gideon versus Wainwright blew that away. It said, no, that's not what's going on. What's going on is that all people accused of crimes are entitled to representation of counsel. It's a general rule. They're entitled to it. So if they're all entitled to it, why do so many prosecutors fight the very issue of fairness and adequacy? You have so many cases out there that deal on the subject, and yet it's so easily just dismissed and brought against. I brought it up in previous podcasts. Why is the government so committed, so dedicated to forcing people into convictions? Why are they not concerned about whether the person's actually innocent or guilty? Why aren't they concerned about whether or not the crime actually happened? All they care about is conviction. All they care about is building up their own jacket, building up their own reputation. All they care about is keep putting people into the prison system so they can continue to get money funneled into them. They don't care about right, about justice, about equality, and certainly not about innocence. They deprive people of their rights constantly. And you have, that's very fact that you had to have the United States Supreme Court even come down and say, hey, wait a minute. Fair here is fair. This guy's not an attorney. You guys are. How is that fair? How can he prove his innocence? Why was it even necessary? Why should this not be common sense? Because prosecutors in government and judges in government are the ones who are making the rules, and they always make the rules to favor themselves, not the defendants. They're charged in duty to their office and their oaths of office to defend their constituents and the people they represent. They don't, clearly. This isn't a problem only in Montana. It is exhibited greatly in Montana, but it's not limited only to Montana. Gideon set the foundation for other historical landmark cases. It set the groundwork for Messiah versus United States. 377 U.S. 201, by the way, was a 1964 case, which states that the government eliciting statements after the request for counsel was prohibited. They could not continue to interrogate somebody if they asked for their Sixth Amendment right to counsel. And of course, one that I've talked about quite a lot, Miranda versus Arizona, 384 U.S. 436, 1966. The establishment that an individual must be informed of their right to counsel prior to interrogation. Statements cannot be used unless they are so forewarned. It's a Fifth Amendment privilege against self-incrimination. So yeah, and it also set the groundwork for civil Gideon, which is also known as the civil right to counsel. It's a movement, less law, because unfortunately, to this day, it's not been established as a standard, such as Gideon versus Wainwright. But it's a movement, and states are slowly gaining some traction here in some states. Montana is not one of them. But slowly, some states are accepting this, and we really need a national standard for it, but we don't. Basically, the civil Gideon movement basically is an effort to try to require attorneys for civil cases that affect basic human needs, such as shelter, sustenance, safety, health, and child custody. And that anybody who is suffering from these issues, these basic human needs, have a right to counsel at no charge. They should not be charged for counsel if they're defending their home against an eviction, if they are seeking food or their own safety or their own welfare, their health, the child custody issue, anything dealing with basic human needs. I'm not talking about suing a multi-million-dollar corporation for, I don't know, a candy bar that doesn't mention that has nuts in it. Maybe that might fall under basic health issues. But if you know what? You left out that this was made in, Alabama and this was actually made in Detroit. Sorry, we're not going to, that's not an issue. Is the coffee too hot? Maybe. Is the coffee really, 100% Cuban? Maybe not. But the idea is that basic human needs should at all times be allowable to counsel. As I said, sadly, this is an as yet unrealized application of law. Like I said, some states have granted limited aid. Montana actually dissolved their public assistance program. Instead, it's pretty much left up to attorneys who are not required under the laws of the state to provide pro bono work. It literally is just a suggestion. It literally is just a suggestion in the Montana Rules of Professional Conduct, which are the documents governing the ethical standards of attorneys, where the American Bar Association, almost said American Civil Liberties Union, where the American Bar Association makes it mandatory that a certain number of hours be committed to pro bono work. Montana makes it an optional choice for individual attorneys, which means it's basically left to whether an attorney feels like giving pro bono work back. They don't have to. They're not going to lose their license, and they're not going to receive any penalty for not doing so. It just comes down to whether they feel like doing it. And quite frankly, the demand for pro bono work grossly outnumbers the number of attorneys in the state. Honestly, they really need a proper advocacy group here in the state. We don't have it. But what getting essentially established is that indigent defendants, people who are too poor to afford it, should be entitled to counsel without cost. In Montana, as unfortunately has become something of a building boulder of a sort, defendants are ordered to reimburse legal fees to the state if they lose. If they're accused and they win, no cost. But if they lose, they're ordered to reimburse. Now, consequently, though clearly unconstitutional, the state is reimbursed for costs it's expended. And yet, in spite of this, Montana remains grossly underfunded, leaving public defender offices inept and incapable of doing their jobs. Montana was actually sued by the ACLU in 2002 for an almost identical problem, which I will go into. But Montana chose to enact the guarantees set forth by Gideon v. Wainwright through a county-based public defender system. The state basically ordered the individual counties to establish their own public defender's offices, basically set aside any idea of oversight. Just, you guys do it, we'll leave it to you, we'll give you a little money every year to do this. What they ended up doing was that they hired and retained a central public defender for each individual county, and that public defender would then contract out with individual private practicing attorneys to do the job. Basically by warehousing cases. And if anyone doesn't understand the term warehousing, it's basically we're going to throw a whole bunch of people through an assembly line and just run them down the line as quickly as we can and as efficiently as we can, because we don't care about their rights. We're just going to go ahead and the more people, and attorneys would literally sign up for caseloads after caseloads. My own attorney was running 3 caseloads worth of clients because he was so good at just funneling them through, bullying them into plea bargains, bullying them into this, leaving them in jail until they bent and bowed to his whims. He didn't care about Eduardo Gutierrez Falla, Ed Falla. By the way, if you're at all interested in looking up the name, spelled F-A-L-L-A. But what this created was where we had absolutely no adversarial system. As attorneys here were loyal to the courts. As I've mentioned before, if you didn't go along with the courts, you upset the prosecutors, and of course the prosecutors were friends with the judges, and if you upset them, your other cases that you had before the court would get denied simply out of retribution for upsetting the court with the criminal cases. So the attorneys that were retained had both an interest in the public defender clients because it was a guaranteed amount of money coming into them, but for their individual paying clients, they had to keep the prosecutor happy, they had to keep the judges happy, because that was the only way their individual paying clients got a fair hearing. An attorney's job as a public defender His primary job was simply to rush as many cases through plea bargains as possible. And on February 14th, 2002, the ACLU sued Montana over it. The case, by the way, is White v. Martz, and it's the First Judicial District of Montana, DV 2002-133. And the reason why it's a district court case is because it was never appealed. They reached a settlement. Before we can discuss the settlement, let me discuss the terms of the case. The ACLU is alleged that the state had abdicated its constitutional duty to counties without guidance or sufficient funding. Sound familiar? At all? There was no state oversight. Consequently, all the county programs were riddled with massive problems. A virtual absence of the adversarial advocacy, high attorney caseloads, the inability of lawyers to meaningfully confer with their clients, an inability to develop a defense for their clients, a lack of investigatory and expert services, excessive plea bargaining, and unnecessary pretrial incarceration. Once again, for anybody who's been watching all my videos all along, you should recognize these things. This is the bread and butter of Flathead County. This is how Flathead County lives. This is how it operates day to day. And in spite of the fact this was settled with the state, and the settlement was entered on January 5th, 2006, in spite of that, it's now 2022 and the problems still persist. They have not changed, they have not gone away. You simply created a state office that now has individual counting offices, and those counting offices are underfunded by the state. Same problem as existed before, the same exact problems. There's an absence of adversarial advocacy. There's a high attorney caseloads. The inability of lawyers to meaningfully confer with their clients because they simply have too many clients. The inability to develop a proper defense. A lack of investigatory and expert services because there's just simply too many clients for an individual attorney. Excessive plea bargaining where the public defenders are simply trying to rush their cases through so they can get to other cases that they're still coming down the pipeline to them. And an unnecessary pretrial incarceration, which, as I've said in a host of other videos, Montana violates the Eighth Amendment on a regular basis, a daily basis, every single case almost basis. They put people in prison under excessively high bails that are too high to pay. The individual cannot pay them. They are often indigent. Remember, indigency? Can't afford an attorney? Why can you afford a $50,000 bail? Of course you can't. If you can't afford to hire an attorney for $5,000, how are you going to come up with $50,000? Excessive bails forbidden by the U.S. Constitution's Eighth Amendment, and yet it happens routinely. And public defenders are powerless to do anything about it because they simply have too great a caseload. As I mentioned, this was settled with the state upon a conditional settlement that Montana pass a statewide Office of Public Defender law, which it did so and signed into law on April 25, 2005. In effect, it rendered the complaint moot because ACLU's complaint basically was against the county system. With a state operating system, a centralized system, the majority of the complaint went away because the framework it was suing against no longer existed. It did not solve the underlying problems. It simply removed the defendants and the proper course of that action. And as I mentioned, though, what was not settled was the lack of funding. The very same lack of funding which was created under the county-based system still exists under the state system. The same lack of funding. Remember, the state was still responsible for funding the county-based systems before. It's still funding the statewide system. But it's still the same level of inadequate funding to actually meet the demand. And remember, the state is getting billions of dollars, has received billions upon billions upon billions of dollars over the last 30 years, 40 years, 50 years to fund the prison for profit system that existed since the 1980s. And precursors before that, but primarily since the 1980s. So you have a system here that receives massive amounts of money from federal grants, block grants, so-called justice block grants, to fund a justice system that puts a bare fraction into the public defender system. because they don't want the public defender system to even exist, so they're going to sabotage it from out the gate by not giving enough money to operate properly, which leads to the $8,500 contempt fee against the head public defender of the state of Montana. Why? Not because the head public defender actually did anything wrong, but because her department has been sabotaged out of the gate by a government that does not want to give rights to indigent individuals because they don't want them to prevail. They want them in the system so they can continue to get money. Welcome to the prison for profit system, ladies and gentlemen. And obviously, as I mentioned, this problem still exists to this very day. Obviously, this order is dated February 2nd, 2022. And for the record, ladies and gentlemen, as I'm recording this, it's actually February 7th, 2022. This is less than a week old. So, and of course, this will be airing on February 8th, just so you know. But this is less than a week old. This is less than a week into the existence of this order. So obviously, this problem still exists. And here we have a judge persecuting the Office of Public Defender for the state legislature's unwillingness to give it the funding it needs. This matter, I wish this is where the story ended. I really wish this is where the story ended. But unfortunately, it's not. This matter is complicated further. Montana courts universally order indigent defendants to repay the state for public defender costs. It's actually a law. The state law is Montana Code Annotated 46-8-113. It basically, the courts encapsulate under the term restitution. The courts order defendants found guilty to pay back their attorney fees. Now, Gideon clearly set forth that states were required to provide aid without cost to indigent defendants. If a defendant cannot afford counsel, state is required to appoint one. The state is required to appoint one. Not an attorney shall be loaned and billed later. That's not what the U.S. Supreme Court said. This right does not vanish upon conviction. And then it's often compounded by a loss of income as a result of conviction. People go to prison. People end up, they've been in jail for an excessive period of time, so they've lost their existing employment. And yet, they're expected to somehow cover a cost they couldn't afford going in with employment in many cases. And yet, coming in without employment afterwards, they're expected to somehow pay this back. Again, we're penalizing the criminals. The criminal justice system is penalizing people for their inability to afford to defend themselves. And once again, an overwhelmed system gives inadequate legal counsel, gives inadequate representation, forces people into plea bargains, forces people into ways just to get these cases off the docket so they can move on to the cases that are still being funneled into their office. You've seen the old cartoons where people's stacks of papers are going like this in their inbox, and they just have just a few in the outbox. This is what we're looking at. No matter how much those attorneys put out, they've always got more cases coming in. And they simply can't keep up with them if they stop and give every case the proper attention it deserves. They can't give these people that are overwhelming amount incoming attention at all if they're giving the cases in front of them the adequate attention they need. So they have to just do the bare minimum. They absolutely have to just get the cases rolling through. Please do this. As a consequence, people receive inadequate representation. People are convicted more often when they're not guilty. It happens. There's just absolutely no framework for fair and adequate representation. But this is a sideline. 18 U.S.C. section 3006A, paragraph F. A judicial officer is not authorized to require reimbursement as a condition of probation, and the judicial conference position is that reimbursement of the cost of representation under the CGA, Criminal Justice Act, should not be made a condition of probation under any other authority. Under federal law, it is against the law, literally, to require a criminal defendant to repay their defense. An indigent defendant they cannot order it as a condition of sentence. They can't. It's forbidden by federal law. The states, however, it's a little less murky, a little more murkier. The water's not quite as clear. There was a U.S. Supreme Court case called Fuller v. Oregon. And for reference, that's 417 U.S. 40. It's a 1974 case. Once again, 417 U.S. Recorder, page 40. Oregon law had a law that required repayment if defendant later became capable of repaying his court costs. If he was prosecuted in, let's say, 2000, and it was determined at that time he had inadequate income to pay an attorney who was represented, a couple years later he went to school, got a degree, got a really good paying job, the court can come back and order him to repay the public defender fees. Essentially required only reimbursement if able. The Oregon law was very specific about how only individuals who later became capable could be pursued into this law. Fuller sued Oregon, and the United States Supreme Court came back and said, no, because the states have an obligation to seek reimbursement for their costs and their expenses, it makes sense that if a person later becomes able to pay this, that the state has a right to pursue that. Even the Montana Code, even Section 46.8113, requires an assessment by the court to determine if the defendant is able to repay. The problem is, Montana doesn't follow that. I myself, when I was prosecuted and I was put into the sentencing stage, never once was there ever a hearing to determine whether I had the financial capacity to pay anything back. Nothing. It was just, and ADFIA's answer was, you might be able to someday, so the court's going to order you to pay it back. Keep in mind, I've been running a youth recreations program. That was my employment. That was where my income, my sole source of income was coming from. They had just railroaded me through a false conviction of a sexual assault against a minor. That conviction barred me from ever again working with youth, and therefore I could not return to my former employment working in a youth recreations program. I had to go to prison for 5 years, and after I returned to the community, I could not even return to my old former work, and a chronic joint pain disease that prohibited me from working in most fields because of the physical demands upon me. Only a job in which I could actually set my own schedule and work in and around my capacities permitted me to work at all. Which is why my writing is so beneficial, as I can actually work that around my own schedule, my own physical capabilities. If I had a deadline to a editor or anything else, it'd make it impossible, because those many days I simply cannot work. My physical, like yesterday, I couldn't walk on my left foot. My ankle flared up, and I literally could not bear weight on my foot. If I was required to report into a job, I'd have to take a sick day. I have to take far too many of those, where I cannot get up at a set time, I cannot get up and move around properly, I cannot sit for an extended period of time, I cannot stand for an extended period of time, and consequently working is nigh impossible to me. Unfortunately, it also means that for lack of funding, I don't have any way to advertise my books. Therefore, I receive very little in compensation for my work. But I'm out there, I'm still trying. I want to be off disability, I simply don't have the means yet. But you can always help support. Go buy my books. By the way, for the record, ronglick.com. That's RONGLICK.com. There are my books. I have 25 publications. Go buy some. Help support me. Help me get off disability. The problem is, as I mentioned, that in my case, there was never a financial capacity hearing ever held. There's not, generally speaking. It's pretty rare to have anybody make an assessment, at least in Flathead County, of whether someone's financially capable of doing it. And quite frankly, most of these people who are indigent going in, who have been incarcerated for an extended period of time, have already lost their source of income. Therefore, by the time they reach sentencing, they don't have income to speak of. They don't have, $100,000 set aside in a bank account. They don't have a life insurance or some kind of a insurance policy that pays them if they're unable to work because of incarceration. Good luck if there's ever a policy out there like that. But the point is, they've lost their source of income. They don't have savings or repositories. They're indigent. They can't afford an attorney. And if they could afford an attorney, chances are any money they did have probably went to try to pay for an attorney. They have nothing left by the time they reach sentencing. So the financial capacity of these individuals who are indigent, which represent a gross majority of the state convictions, is simply incapable. There's no way they could hold a competency hearing and determine if the person was capable of paying because they wouldn't be able to. Therefore, the state simply bypasses that requirement, the state courts do, and just order them to pay it back regardless of whether they can or they can't. There's no determination. But even Montana law requires it, they just don't follow it. Surprise, surprise, Montana doesn't follow the law. As I mentioned, with a 5-year prison sentence looming over me, with a conviction that prohibited me from returning to my former employment, there was no way I was going to be able to repay anything. They didn't care. They still ordered. And the only reason I ever was able to pay it off is because I was in an accident receiving an insurance settlement, and I put that insurance settlement to pay off those fines so I would be able to be free and clear. I can't tell you the number of people I've heard of who are ordered to pay court-ordered fees and are held beyond their sentence time because they can't pay off the fees in time. They're given a 5-year probation sentence. In that 5 years, they can't pay off their $10,000 reimbursement for attorneys. And as a consequence, they're held and continue to be held under probation, and they're not released. Gross violations of their constitutional rights, but welcome to Montana. The point I'm trying to make here is that I would argue that even a later reimbursement is unconstitutional. If at the time of prosecution the person is indigent, there's the mark. If at some mercurial future date a defendant might be able to reimburse this, is inconsequential. The question is the person capable of affording counsel to defend themselves? If they cannot do so at the time they are prosecuted, they cannot be held to later come back and reimburse it. I mean, they're not allowed to go retroactively back and hire a real attorney, retry the case, and come back and redefend themselves with a real attorney who's not burdened by the inadequacies of the public defender system. So why are they required to go back and repay the public defender? It's a catch-22. You can't win in that scenario. It cannot be constitutional to retroactively go back and require someone who could not pay at the time he was prosecuted to pay because he fell into some money later on down the line at some point. Indigency in any other aspect is not handled this way. I mean, we have indigent medical care. You go to a hospital and say, I can't afford medical care. They waive your medical care. They don't contact you 3 years later and say, by the way, have you received income that's sufficient to pay for your medical care now? No, it's waived. It's done. You could not pay for it at the time it was administered. It's waived. Indigent health care, housing, food stamps, assistance of all kinds across the board are not required to be reimbursed if the person becomes financially capable of supporting themselves. If the person gets gainful employment after being on unemployment, they're not required to reimburse the unemployment benefits. If the person at some point gains insurance to be able to cover medical costs, they are billed from that date forward, not retroactively back to when they couldn't afford it for the rest of their life into infinity. No reimbursement of public assistance is required of any kind, except if you are accused of a crime and you are convicted. You're going to be slapped even further with reimbursing the attorney fees. So if you're prosecuted and you lose, you can be made to repay. Did you choose to be prosecuted? Did you choose to face this consequence? No. Did you choose to be given inadequate counsel through an Office of Public Defender system that's overburdened and underfunded? No. If you had the money, you'd hire a real attorney who didn't have those limitations. So how is that fair? The truth is the system in Montana is clearly broken. I mean, it just clearly is. Surprise, surprise, Montana courts do not follow the law. I mean, and just the sheer audacity of assuming that they might follow the law is just preposterous. Justice in this ruling by Judge Harris, who was assigned the entire burden of the state's obligation onto the Office of Public Defender. The Office of Public Defender is not responsible for the state legislature's budget. It's not responsible for the entire state. It is obligated to perform a function, but the state has an obligation to make sure that the the criteria and the means exist to perform that function. Just as the state is required to form the Office of Public Defender, it must also be required to fund the Office of Public Defender. If it does not do so, it is not the Office of Public Defender's fault that it cannot do its duty. It's the state legislatures, and they're the ones who should properly be penalized. Misapplying even the standards that are enacted into law does not make them fair, nor does it make them equal. In fact, I quoted in my last podcast, I didn't have the case in front of me, but I have it now. I quote Yickwo a lot. But there's a case that's called Yickwo versus Hawkins. And as I've said before, it's 118 U.S. 356. It's an 1886 case. That's how long this standard of law has been in place. 150 years almost, this law has been in place. Law that appears fair on its face, but applied with an evil eye and unequal hand, is unconstitutional. This is a clear application of that standard. If indigency is established for prosecution, the right to counsel at state expense should not be retroactively rescinded. If the law exists to make a fair and equal opportunity for an individual to be defended, just because they are indigent, to retroactively come back and require some of those people to reimburse if they become eligible later on, is unconstitutional in its application. It's applied with an unequal hand. Not everybody's given that same standard. And it's an evil eye designed to penalize the individuals who receive public assistance and who are indigent and incapable of paying for their own counsel. But worse, in a state like Montana, where that step isn't even followed, it's required by law, but it's not followed. It does make it an evil eye and unequal application because, of course, only the indigent who cannot afford counsel are the ones who are held to this law. The problem is that the fact is, if you're unable to pay for counsel when you are prosecuted, that's the standard. Not 5 years down the line, did you get a college degree, or did you get an inheritance, or did you get in an accident and receive a $100,000 settlement? That's the standard. You cannot retroactively go back and hire a non-OBD attorney, a non-public defender attorney. So why do you have to go back in time and repay the public defender? The real irony here is that in spite of this fact, Montana is being reimbursed. Montana is being paid back for the expenses it pays out. But the money is not paid to the Office of Public Defender. It's paid into the general fund. The money is not allocated back to the Office of Public Defender, which means that the state is the one benefiting, not the Public Defender's Office, who is supposedly being reimbursed for this. The state just takes the money collected from the reimbursements, puts it into the general fund, and then continues to underfund the Public Defender's Office. In spite of the reimbursements, in spite of the fact that it's being paid back for its expenses, it's not putting those repayments back into the public defender system. It's putting it into the general fund, where it can spend it on anything. It can spend it on a hole in the ground caused by an ice block. It can put it into a banner to celebrate whoever's birthday they want to celebrate. There's nothing that allocates that says it has to go back to the Office of Public Defender. In fact, it doesn't. And remember, the state's receiving billions of dollars over these billions upon billions of dollars ever since the 80s. It funds the criminal justice prosecution side, it funds the judges, it funds the prison system, but not the public defender system. Why? Because they don't want people defended. They want people in the prison system because that is what funds their prison for profit. They have to have bodies inside the system, guilty or not guilty, put people into the hole, put them into concrete walled structures, and call it justice. It's not justice. I keep using the analogy over and over again. I say that if it walks like a duck, it looks like a duck, it quacks like a duck, it's probably a duck, even if it's holding a sign that says it's a chicken. If I see a duck walking around and waddling around, I recognize it as a duck, but it's wearing a sign across the check on a big string that says, I am a chicken. Do I suddenly say, oh, that's not a duck, it's a chicken? Of course not, it's a duck. If I hold a sign on my chest that says, I am black, do I suddenly become black? Of course not, I'm not black. Nothing against black people, by the way. I have Native American ancestry, I'm Apache, and I'm white Anglo-Saxon. But I'm not black. It's just a fact. I mean, if I do have black in my ancestry, I'm not aware of it. But I wouldn't be bothered if I did, but I'm just not aware of it. The fact is, it doesn't change it just to call it something else. The bottom line here is that there's a clear bigotry amongst the judiciary against indigent defendants. They don't want the indigent defendants to have a fair hearing. They don't want them to have adequate counsel. They don't want them to have anything. And this motion coming down from Judge Harris is a perfect example. Bigotry extends to the Office of Public Defender because the Office of Public Defender is defending these people. They're persecuted for something they're powerless over. Attorneys have an obligation to act in the best interest of their clients. But just as abusive process is an example of how judges work against the Office of Public Defender, it's also how they penalize poor defendants. Because poor defendants don't get adequate counsel, they don't get to defend against illicit prosecutions, they don't get to defend themselves when they're innocent, they're convicted when they're not. They're not given a constitutional right to due process. But the court doesn't care about due process. The court cares about whether or not they can just funnel these defendants through the court system and get them into the prison system so they can start ticking off the number of people they can have incarcerated so they can get more money back from their block grants. If an attorney is incapable of giving professional care to excessive clients, the attorney has an ethical obligation to say, no, I can't do it. Yet Judge Harris wants an overburdened Office of Public Defender to assign inadequate counsel to defendants. Why? Because it only funnels people through the system and into prison that much easier. The more overburdened the public defender's office is, the more overburdened the individual counsels and attorneys working for the public defender's office are, the less that they can defend the individual defendants, the less attention they can give to individual cases, the less likely somebody is to prevail against a criminal charge. And the only party that benefits from this are the prosecutors and the judges. Clearly, actual defendants gain far less and are far more likely to be convicted. The agenda is set out: sabotage cases by penalizing the Office of Public Defender for inadequacies created by other state actors. The public defender did not submit a budget to the state legislature that was inadequate. The state legislature made a decision on their own to underfund this department, knowing full well that this department is complaining about being underfunded, has been complaining about being underfunded. Long before there was a statewide Office of Public Defender system, there were complaints about it being underfunded. This is why the ACLU sued Montana. Was for this reason. It was because the state left the counties incapable of doing it because they didn't fund adequately the public defender system. And yet, here we are with a statewide system and we're into the same exact problems. It's like I said, you can have an attorney, but if they aren't able to assign adequate care to the cases, if they can adequately handle 20 cases and they are given 50, with constantly more and more and more and more and more and more cases adding to their tally, they can't stop and give the attention to the individual cases that is required. They simply don't have the capacity. They can't do the legal research, they can't do the briefs, they can't offer proper defenses. The best they can do is just try to get them through the system as quickly as possible, and that 99% of the time means plea deals. They certainly can't afford to do trials. fate's preserve, they actually are expected to do trials for each one of their clients because their clients insist on it. They can't. They physically cannot do it. And judges like Judge Harris, who sit here and penalize the Office of Public Defender for not doing what they are incapable of doing with a moral and ethical compass, where's the justice? In the end, who benefits from a corrupted system like this? It's certainly not the defendants, it's certainly not the people of the state. And remember, as I've said before, these individuals are charged with representing the best interests of their constituents, of the people who they work for. But they are throwing the people they work for into prison in massive numbers. They're not representing the people, they're representing their own interests, they're representing their own pocketbooks. And there's no justice when that happens. Obviously, the only system that benefits is the prison for profit system, which only is the empowerment of the Great Montana Conspiracy. Because without money, the incentive goes away. As always, as I end this, if you are watching this on YouTube or if you're watching this through any other platform, like and subscribe. Share it with your friends. We're over 900 followers on YouTube right now, which is putting us within shot's distance of our target of 1,000, which would be fantastic. We could then take advantage of YouTube's opportunity to promote us through their framework and hopefully get even more subscribers. But the idea here is that helping support our cause is essential. If you're able to support us financially, information is attached to this video. If you're, again, watching this on a platform that does not include the text of this video, please visit us on monspiracy.podbean.com. I guarantee the information will be attached there because that's where this podcast originates. As always, please be safe out there. It's a dangerous time. And whenever possible, please be free. Thank you.